Welcome to Outside Views EU. Today we're exploring the EU's approach to intellectual property laws and what it means for innovation and creativity. Intellectual property, or IP, plays a vital role in protecting ideas, inventions and creations, encouraging people and businesses to keep innovating. But as technology advances and the global economy changes, so too does the landscape of intellectual property rights. In the EU, intellectual property laws have been developed with a balance in mind, aiming to protect creators while fostering an environment that allows for the free flow of ideas and creativity. So what do these laws entail, and what are the broader implications for innovation and creativity? First, let's define what we mean by intellectual property. Intellectual property refers to creations of the mind, everything from inventions, literary works and designs to symbols, names and images used in commerce. In the EU, IP is primarily divided into four main categories: copyrights, trademarks, patents and designs. Copyrights protect original works like books, films, music and art. Trademarks cover logos, brand names and symbols that distinguish one business from another. Patents apply to new inventions, giving inventors exclusive rights to their inventions for a set period. And lastly, designs protect the unique visual characteristics of products, ensuring that creators have exclusive rights to the look and style of their designs. The EU has worked to harmonize IP laws across its member states to create a unified legal framework. One of the primary reasons for this harmonization is to make it easier for creators and businesses to protect their IP rights across the entire EU without navigating a patchwork of national laws. By creating a more consistent system, the EU aims to foster a single market where ideas, products and services can move freely, benefiting both creators and consumers. But achieving this balance between protection and freedom hasn't been simple, and there are some challenges along the way. One of the most important tools in the EU's IP arsenal is the European patent system. The European Patent Office, or EPO, allows inventors to apply for a patent that, once granted, can be recognized in multiple EU countries. The system is especially valuable for companies involved in research and development, as it gives them broader protection for their inventions and encourages investment in new technologies. However, patents can be a double-edged sword. While they incentivize innovation by protecting inventions, they can also create barriers for competitors, particularly smaller companies, that may struggle to navigate the patent landscape. The EU has worked to streamline the patenting process and make it more accessible, but challenges remain in ensuring that patents do not stifle competition. Another critical area is copyright law. Copyright is essential for protecting creative works like films, music and literature, and the EU has made efforts to modernize copyright rules to reflect the digital age. The EU Copyright Directive, implemented in 2019, aims to bring copyright law up to date, particularly with the rise of online content sharing. And one of the most talked about aspects of this directive is Article 17, previously known as Article 13, which requires online platforms to take more responsibility for copyrighted content uploaded by users. And this has had significant implications for platforms like YouTube, where user-generated content often includes copyrighted materials. For creators, the directive is seen as a victory because it requires platforms to share revenue with artists, musicians and writers whose content generates views and clicks. However, it has also sparked concerns about censorship and potential impacts on freedom of expression. Platforms are now using automated filters to detect copyrighted content, but these systems are not perfect and can mistakenly flag legitimate content as copyright infringement. And this balance between protecting creators and allowing for free expression remains a challenging aspect of IP law in the digital age. Trademarks are another cornerstone of EU IP law. A trademark protects symbols, logos, and brand names that identify a business's products or services. The EU has a unified trademark system allowing businesses to apply for an EU-wide trademark through the European Union Intellectual Property Office, or EU IPO. And this approach simplifies the process and allows companies to secure brand recognition across all member states with a single application. For companies, especially international brands, the system is invaluable for building a consistent brand presence across Europe. However, as with patents, trademarks can sometimes become contentious when similar or identical trademarks are claimed by different businesses, leading to disputes over brand identity and consumer confusion. The European Defence Fund, launched in 2017, also plays a role in supporting innovation in the IP landscape. The EU has invested in projects that encourage the development of new technologies, with specific funds allocated for defense-related research and innovation. By fostering technological advancements, the EU hopes to create a competitive edge for European industries, especially in areas where innovation is crucial, like cybersecurity and defense. And intellectual property rights are critical in these fields to protect sensitive technologies and ensure that European companies can compete globally without the risk of their innovations being copied. While IP laws provide protection, they can also create challenges for startups and smaller creators. Registering patents, trademarks, or copyrights can be costly, which poses a barrier for smaller companies and individual artists. The EU has recognized this issue and has introduced initiatives to help small businesses and independent creators protect their intellectual property without excessive costs. The EU IPO, for instance, offers funding and support programs aimed at helping small businesses navigate IP registration and enforcement. And these initiatives are designed to make the system more inclusive, allowing creators at all levels to protect their work and contribute to Europe's innovation ecosystem. One of the ongoing debates around IP in the EU is how to strike the right balance between protecting intellectual property and fostering innovation. Too much protection can lead to monopolies and restrict access to knowledge, while too little protection can discourage investment in new ideas. And this balance is especially relevant in the pharmaceutical and technology sectors, where innovation often requires large investments, and strong IP protection is crucial for recouping those costs. In these industries, patents give companies the time they need to bring new drugs or technologies to market without facing immediate competition. However, when patents expire, it's equally important that knowledge becomes available to encourage further innovation and improve access to technology and medicine. For the EU, another key consideration is global competitiveness. As other regions like the United States and China continue to push forward in technology and innovation, the EU aims to position itself as a leader in intellectual property. By creating a robust and harmonized IP system, the EU hopes to attract businesses, researchers, and creators who view Europe as a place where their ideas and creations will be respected and protected. And this goal of global competitiveness is closely linked to the European Innovation Council, which funds high-risk, high-impact research and aims to drive breakthrough innovations. IP rights are a critical part of this strategy, as they give European innovators the security they need to pursue ambitious projects. And one of the more forward-looking elements of EU IP policy is its approach to artificial intelligence and emerging technologies. The EU is aware that IP laws must evolve to keep pace with AI, data, and other transformative technologies. For example, who owns the rights to a work created by an AI? How should data be protected in a way that encourages its use for innovation while respecting privacy? These are questions that the EU is beginning to address, with a focus on creating a legal framework that supports both innovation and ethical standards. As technology advances, the EU's intellectual property framework will need to adapt to ensure that it remains relevant and effective. So in conclusion, the EU's intellectual property laws are about more than just protection. They are about creating an environment where creativity and innovation can flourish, while initiatives like the European Defence Fund and the EU IPO support for small businesses, the EU is building a comprehensive IP strategy that balances protection, access, and competitiveness. And as the world changes, so too will the landscape of intellectual property. And the EU is positioning itself to lead in this evolving field. And that's why, once again, I can only say thank you for tuning in to Outside Views EU, where we break down the policies shaping Europe's future. Remember, intellectual property isn't just about ideas. It's about turning those ideas into reality and ensuring they can thrive in a world where innovation is key. Until next time, and the next video is right here in the end screen.